Hello everyone, it's Richard Lewis here again with another video. Today, going to be talking about a story I've been covering since it began, and yet for some reason, every time I publish something about it, it doesn't really seem to, blow up or get discussed very much. And I think it's crazy because I think it's a pretty important story, and it's going to hugely shape the landscape that we all operate in if we work in gaming or esports or even have a cursory interest in those hobbies. I am, of course, talking about the ongoing, yes, it's still ongoing, lawsuit between FaZe and Tfue. Which people don't seem to be aware is still ongoing. I think people think they settled out of court. No, there's a lawsuit, there's a counter lawsuit. We've been going through all of the legal processes, and it looks like it's going to proceed to trial now that we've had some summary judgments, and that's what I'm going to be talking about in this video. I did publish an article over on Deserto, which you guys can go and find. It's there. If some of this is confusing for you, it might be a little easier to digest in a written format, or maybe it's easier for me to break it down. But basically, what's been going on is, and I'll try and explain. I'm not a lawyer, so I'll try and explain this in as simple terms as possible, as my brain understands them. When you present your arguments to the court, there are these things. There's this period where you're having the back and forth, and it's called motions for summary judgment. Summary judgment is basically, this is so obvious that it needs to go the way of the law, and it usually comes with an example of the relevant case law, that you should just rule on it now. There's no need for us to argue about this at trial. So before we get there, let's have a ruling on it. And that's what a motion for summary judgment is. Now, for those who have been following the story, you'll know that originally it was Tfue and his counsel trying to sue FaZe, and then FaZe decided they wanted to counterfile a lawsuit against Tfue. So we're really talking about two lawsuits here. We're talking about one that's going to be in New York, which is where FaZe filed, and now we know there's going to be one in California, which is where Tfue filed, because of the all-important Talent Agency Act being applicable to residents there. So this was a terrible, terrible day at the office, so to speak, for FaZe. It really was. They submitted requests for 6 summary judgments and had 5 of the 6 dismissed as having sort of no merit. So pretty crazy. I haven't seen that happen in any of the lawsuits I've covered before. But then again, I haven't seen so many motions for summary judgment submitted. So maybe there's a legal mind who watches my channel that wants to chime in and basically say how normal it is, what the chances are for summary judgments to be dismissed. Kind of feels a 5 out of 6 is a little bit high. But yeah, let's get into what was dismissed and what was under consideration. You can see I wrote it down here. It wasn't a great day for FaZe Clan. It found most of the requests for summary judgment denied by Judge Rakoff, only being granted one of the 6 requests they made. The judge ruled that Tenny will not be able to avoid having to answer to a Southern District of New York court for FaZe's counterclaims. That was fairly straightforward. Tfue was kind of arguing that all of the cases, even the counterfiling, should be held in California, so the Talent Agency Act will be applicable. Basically, that's just, it had no merit. The judge said no. They filed it in New York. They have offices in New York. They believe they have a grievance in New York. It's going to get resolved in a New York court. So Tfue will have to sort of face the music, so to speak, for the FaZe counterfiling. As you'll see, though, I mean, so much goes the way of Tfue in this. It's actually probably going to be a cakewalk for him, and I wonder if now we're getting closer to perhaps a settlement agreement, frankly. So the first and most crucial thing, the California Talent Agency Act has been the most debated part of this case. What is that? Again, if you've been following the story, you know that if you want to act in a manner where you procure work and sort of offer services and do sponsorship deals for somebody, basically if you act as an agent for someone in the entertainment industry in the state of California, you have to have a license. FaZe don't have a license. And that's why they've been trying to move away from this argument that the California Talent Agency Act should be applicable to them. They've tried everything. They've said, listen, we've got offices, we're incorporated in Delaware, we've got offices in New York, we don't actually do any business in LA, something that's a provable lie. And they've tried to wriggle out of sort of answering to the California court so they don't have this Talent Agency Act law be applicable to them, because it would essentially invalidate the contract. Lo and behold, the judges said that because they have done work in the state of California and that Tfue was a resident in California, the original jurisdiction of California is the appropriate venue for his claim. He cannot waive those rights away, so it's not even an issue of Tfue being able to say, well, I did agree it wouldn't be applicable. You cannot even waive those rights voluntarily. They're so fundamental to the entertainment law and how it operates in California. So they are going to apply, his case is going to be heard in California. And the court even called FaZe out on their bullshit and said, listen, FaZe, you said you didn't do any work in California, but we know that your employees conducted discussions with Tfue in Los Angeles at that time. So they got called out on essentially lying in their argumentation. The other thing that they wanted summary judgment on, and you guys will love this bit, was they, in their lawsuit, they're now saying, hey, we didn't try and claim any of the Fortnite creator code money. We didn't try and claim that, and we had no intention, but we believe we're entitled to it, so now we're going to exercise our right to act upon that intention. So the summary judgment there, the court have said, first of all, we're denying it on the grounds that Banks, in a deposition is where you basically interview someone for testimony, that you will then introduce into a trial should it be necessary or pertinent. He said in his own deposition that they when they had no intention. They weren't going to collect that revenue. They'd agreed they weren't going to collect that revenue until they filed their lawsuit against Tfue. Also, they'd put a video out publicly saying that, if you remember. They said, oh, yeah, we weren't going to take that cash. So the court were like, well, you said as part of the agreement you weren't going to take that money. You can't just change it now that you're pissed off. I'll read you directly from the court documents. The court accordingly takes note of the overwhelming evidence introduced by Tenney that the parties prior to this litigation did not intend the term in-game merchandise to encompass Tenney sales through the Support Creator program. First, Tenney cites deposition testimony from Richard Benson, aka FaZe Banks, a part owner of FaZe Clan, that we never had collected the creator code revenue, and up to this point in time we had no intention to do so. Second, and even more persuasively, Tenney includes in the record a link to a YouTube video published by FaZe Clan on May 23rd, 2019, in which a representative of the organization expressly states that the contract between the parties does not require Tenney to split his support of creator revenue. And just to close off that argument, they said, the YouTube video raises a genuine dispute as to whether FaZe Clan is equitably stopped from collecting the revenue, particularly since the video was published as part of a public relations offensive to protect the organization's image. So, in closing, basically what the judges said there is, no, absolutely not. You cannot simply just change your mind on something that was contractually agreed upon, and the proof of it is out there in the public domain anyway, and you yourselves put it out there into the public domain to try and make the person you're now suing look bad. So, unbelievable fuck up from FaZe there, guys. I mean, seriously, there was a lot of questions at the time. Why doesn't the lawyer come and get Banks? Why don't we stop Banks from talking? Why is fucking Lee Trink putting out these embarrassing FaZe to fuck up? It's only going to hurt them. And lo and behold, they might have won the battle in the court of public opinion, but it's absolutely hurt them in court here with a very real, tangible example of that they're not going to be able to claim that money now. Another blow for FaZe came in regards to the judgment that pertained to the non-compete clauses used in the original contract. FaZe had argued that Tenney had violated his contract by not adhering to the provisions of the non-compete clauses contained in their agreement. So this was in regards to they had a rule in the contract where they basically said that once the contract ended, he wasn't allowed to even stream his own gameplay for anyone, even as an individual in any capacity, because it would be infringing. He would be essentially acting as a competitor to FaZe if he were to do that. So non-competes are stupid American things. You don't really see a lot of them in Europe. It's a very American concept, and often they're not even held in certain states. Certain states have upheld in certain states, I should say. Certain states are very favorable towards workers getting other jobs and moving on, and a lot of states have said that non-competes are too broad in what they prevent you from doing and what classes as a competing business. Now, under 16600 of California's Business and Professions Code, which was invoked by Tfue's lawyers as a defense, the law suggests that in-term non-competes cannot be applied to independent contractors. Now, remember, when the contract was leaked, seemingly by FaZe, the way that it came out, if you remember, Tfue said release the contract publicly. Banks said we were going to release it. Then mysteriously it got leaked, absolving anyone of any legal ramifications. So it said explicitly in the original agreement that he was an independent contractor. Why do companies do that? Because if you're an independent contractor and not an employee, you don't have certain rights. I'm not legally obliged to provide them. So it's a way that people do try and get around that particular thing. And again, from the court document itself, although California courts have read 16600 not to bar in-term restraints in a contract between employer and employee, the court document, these cases are in I can never say this word, in opposition, because Tenney was not FaZe Clan's employee. So very simple, cut and dry, how this argumentation even gets made when the terminology used in the contract is it's plain English. It's very easy to understand. Then the other thing that was notable was that FaZe had some other summary judgments put in, which were kind of about the trade secrets and that sort of stuff. Not as important, not as big in relation to the case. Now, it wasn't great for Tfue either, because Tfue had some motions for summary judgment which were denied, and this was that he wanted a ruling saying the contract had been breached. It was completely invalid because they didn't pay him his money in what was stated as a timely fashion. And this was true. I think he was only getting $2,000 a month anyway, which is still mind-blowing to me for somebody of his talent, ability, and incredible explosive growth, that he was still getting $2,000, that they didn't look to renegotiate quicker. But a lot of people assume that if we're in a contract and I don't pay you your money on time, it's a material breach, is what they call it. Now, not always. And in this instance, that certainly the court doesn't see it that way. And there's a few details as to why. So they said that it wasn't a material breach because they had, even though they delayed payments, the money was then subsequently paid, and during that time, other duties were performed by both Tfue and by FaZe. So you enter into what is called an implied in fact contract. So there is no way to determine whether or not they had an implied in fact contract ongoing at this time based on the activities of both parties. So that debate will proceed to trial. And the other thing was this argument of tortious interference and personal enrichment claims. Now, the FaZe argued that Tfue had gone out of their way to harm the business, interfere with contracts of other gamers they had under the umbrella organization. Tfue obviously wanted that dismissed and argued he hadn't done it. And there was one aspect of it in the previous run of rulings on summary judgments where his public tweets, which certainly could have harmed FaZe's business, were actually protected speech under New York's laws. So all the shit he said about FaZe, completely opinion-based, even though it might harm their business, it's protected speech. They can do absolutely nothing about it. They can't seek any form of damages in relation to it. But it did say here that in Tfue's own deposition, so he tripped up a little bit here, he did say that he had knowledge of sponsorship deals and the means to contact representatives from those brands. What he'd done was he had actually gone out and said, listen, don't negotiate through FaZe, negotiate through me, and maybe I'm going to leave and we can have this relationship now. So based on that, they're now saying, well, let's go to trial and see what you actually did. So it's going to be discussed as to whether or not there are some grounds for compensation. Incredibly, even with everything that went against FaZe, under that basis, under the common law doctrine for personal enrichment, they could still actually make a claim against Tfue and get some money back. That's my understanding of it. And again, if I'm misinterpreting that, you guys can just tell me below if you're a lawyer or a law student. You know, I'm just a guy that's just read a lot of case law. That's all I am. So it was a bad day overall for FaZe, a few little steps for Tfue, and we are going to go to trial now. All the motions for summary judgment, I believe, have been done. They've now moved to where they're going to talk about case management. So this is where you start talking about any other further stuff that you want to introduce at trial, any other evidence, any other depositions that need to be taken, and we're going to set a date. And as I said, what you have to remember here is this is potentially huge for all of esports and gaming. Why? Because if the Talent Agency Act upholds, and if you run that kind of business in California, well, the way that esports orgs and gaming orgs operate, it's going to have to change because people are going to be in violation. It could actually set off a chain of lawsuits from other influencers and esports athletes. It's one of the biggest cases we're going to have in gaming history. So it kind of blows me away a little bit that people aren't talking more about this, but I guess we'll wait until trial, or maybe when trial's been concluded. We might even see a settlement. Who knows? But anyway, I really wanted to talk about it and bring you guys up to speed with what's been going on. And just follow my reporting at Deserto if indeed you're still interested, or you can follow me on all of this doobly-doo bullshit round here. Anyway, yes, we're one day closer to getting my stuff back, one day closer to getting some lights in here, one day closer to getting a better microphone, one day closer to a fucking haircut, hopefully. As always, I thank you for the support, and I will see you on the next video. Take care.